Welcome. We're just going to give it a minute or so. Welcome. We're just going to give it to 1:02 and then we're going to start. Thank you. Okay, I think we're about ready to get started. Welcome to Essential Human Resources Compliance Topics. This is brought to you today by SCORE Staten Island, where our mission is to foster vibrant small business communities through mentoring and education. Today is a typical educational webinar that we bring to you free of charge. I also want to thank Flagstar, who is a great sponsor, and a special thank you to Karen Hall from Paychecks, who has supported us before, providing some critical information for those who have employees. Next slide, please. So for today's webinar, your line will be muted. Please use the Q&A versus the chat. I will be monitoring those questions, and after each section, if there's a specific question for that section, we will do it at that time. Copy of the slides and recording will be sent to all attendees, and there will be a brief survey that will be sent to you at the end of this webinar. We really encourage you to complete that. It gives us tremendous feedback and allows us to continue to provide educational webinars that meet your needs. So with that, Karen, if you wouldn't mind, thanks.
Welcome, everybody. I'm excited to bring you this training today. Bart and I were talking about different topics that might be of interest to you, and I suggested this just kind of as an overview. In my current role at Paychecks, I help, I have somewhere around 70 small businesses that I work with as their HR consultant. And a lot of the topics we're going to go through today are the topics that I talk about a lot with them. So hopefully you find it eye-opening. Hopefully you learn something. It is divided down into a couple of different subjects. So we will, at the end of each one of those topics, we'll pause. And if you have any questions that have come through, we'll answer them at that point in time. If you think of them afterwards and we talk about them at the end, that is fine as well. Just got to get the legal disclaimer out of the way. The information in these materials, and it's being provided by me, should not be considered legal or accounting advice, and it should not be a substitute for legal, accounting, and other professional advice where the facts and circumstance warrant. It is provided for instructional purposes only. The content contained in a seminar reflects the most current information at the time of its release, as of today. So what are we going to talk about? So these might not seem like the most important HR topics, but in order to operate as a successful business and to minimize the risks of fines and penalties, it's important, critical that we meet the criteria in these areas. So the first thing we're going to talk about, and very, very timely, right, with the political atmosphere and what's going on out there, we're going to talk about I-9s. I-9s can be regularly audited by U.S. Immigrations and Customs Enforcement, ICE, and may come with substantial penalties. All employers with employees that are hired after 11/6/1986 must have a completed I-9 on file for their employees. Now we're going to pop over to wage and hour. There's going to be a little bit of a difference. We're going to talk about the federal guidelines for wage and hour, and most states follow that. New York has a couple of special things that I'll try and touch on for you when it comes to wage and hour laws. Leave of absence management. A lot of times when I talk to my clients, they're like, well, we're a small business. We don't have, FMLA doesn't apply to us. And you're right, FMLA may not apply, but there are other leave of absences that you have to comply with. So just to make you aware of some of those. Workplace investigations. Whether there's a claim of harassment, discrimination, or discipline, an investigation may be warranted to determine what's going on and if you have to take any action. So just kind of an overview of what those investigations should look like. And then finally, discipline and termination. This is by far one of the largest topics that I see questions on. When can an employer take discipline, or when can they terminate an employee? So we'll go through some common ground, some common areas, things to start thinking about when those situations come up. All right. I-9 documentation. Under the Immigration Reform and Control Act, IRCA, employers are required to verify the identity and authorization to work in the United States for each employee hired after November 6, 1986. All U.S. employers must properly complete the Form I-9 for each individual they hire for employment in the United States. Form I-9 must be completed for citizens and non-citizens. Both employees and employers, or an authorized representative of the employer, must complete sections of the form. The Form I-9 is not completed for independent contractors or 1099s. So let's review a little bit of information on these Form I-9s. First, on the Form I-9, an employee must attest to their employment authorization, and they must complete Section 1 of the form no later than their first day of employment, but not before accepting a job offer. You don't want to make a habit of giving this as part of an application packet, because it does have citizenship status, and you don't hire somebody, they could turn around and say, well, you didn't hire me because I told you I wasn't a citizen. So only after a offer has been made, and it should be completed no later than the first day of employment. So you can give it to them beforehand, but if they don't complete it beforehand, that first day of work for you, they got to complete it. With Form I-9, the employee must provide documents verifying their identity and employment authorization. A list of acceptable documents is provided on the second page of the form. While you must provide employees with a Form I-9 instructions and list of acceptable documents, you cannot specify which documentation the employee must provide. You can't say, well, on your first day of work, bring your driver's license and your Social Security card. You can't tell them specifically which ones. You can tell them that they need to bring in identification that proves their identity and their legal right to work in the U.S. You can give them the instruction page that has all the documents, but you can't tell them specifically which ones to bring in. By the employee's third day of employment, you or your authorized representative must examine the employee's original documents, determine if they reasonably appear genuine, and if they relate to the employee, right? So the ID, you're going to look at it, you're going to look at the picture, you're going to look at the name, look at the person. It appears to be the right person, right? Do they appear to be genuine? We're not document experts. So if it appears to be genuine, that's all you care about. Is the name the same as the name that's on, let's just say it's a Social Security card. Is it the same name that's on the ID that they gave you? Does it appear to be right? Is it blue and white, or is it yellow and orange, right? Just a general idea of what those documents are going to look like. You don't need to be Googling and really, really going into it. If it appears to be valid, that's good enough for you. Employers should not accept expired documentation, and employers also should determine if they're going to retain copies of their employees' documents. If an employer decides to retain copies of their employees' documents, then the employer must maintain copies of all documents and be consistent in their practices. So this is where, there's pros and cons to each side, right? By keeping copies of the documents, you're proving that you physically held those documents in your hands, which is the requirement. If you don't have copies of them, how do you prove that, right? But if you have copies of the documents and they are wildly fraudulent and a reasonable person would have caught it, you're opening up the door to that piece. Plus, you must keep it for everybody if you have it for one. So it's up to you. I've spoken to attorneys that feel you absolutely shouldn't keep them, and I've spoken to attorneys that say you absolutely should keep them. So as you choose, as long as you're consistent. Employers must retain the completed I-9 form for a designated period and make it available for inspection by authorized government personnel. Employers should keep all Form I-9 documents in a centralized file separate from the employee's general personnel file. This can help expedite both internal audits and audits from authorized government agencies, and it also serves to limit an auditor's access to other records in an employee file. Employers are responsible for notifying employees when work authorization is about to expire, and it's recommended that employers conduct internal audits on completed I-9 documentation on an annual basis. Now, a couple of things. If I gave a passport when I came to work for you and my passport expires in 5 years, you don't have to ask me for a new passport. That doesn't have to be reauthorized. It was valid, and you verified that documentation on the day that I started work. The only people that you will have to go back to is anybody that's on a work authorization that is for a limited amount of time. And generally, it's between 1 to 3 years that somebody's granted an employment authorization. So you would have to know when that's happening, and you would have to let the employee know beforehand to update it, because technically on the day it expires, they can't work for you anymore. So to prevent business disruptions, I generally recommend my clients, notify the employee about 6 months out that their information is going to expire, and that they will not be allowed to work after that expiration date, to kind of give them a little nudge to keep them moving forward. So here's some resources. These are all links. When you get sent out the deck, you'll be able to go and visit any of these sites if you have additional information. Were there any questions that came in so far?
No, but I do have a question on the
Sure.
driver's license. What if it's required for the job, right? You're going to be driving, so obviously.
Separate. So that wouldn't be for the I-9. If you need the driver's license because they're going to be a driver for you and you need to run an insurance check and you need to keep it on file as part of your insurance coverage for the job, then yes, you can ask them specifically for that. But for the I-9, they need a document that proves their identity, and they need a document that proves their legal right to work in the United States.
Got it. Thanks. There were no other questions.
All right. I'm surprised. I thought for sure we'd have questions on I-9s. All right, wage and hour considerations. So the FLSA, otherwise known as the Fair Labor Standards Act, it's a really old law. It's been around for a very long time, and it's kind of still what we follow. It was enacted to protect workers against unfair employment practices and promote full employment. The law regulates federal standards for minimum wage, overtime, child labor, and record keeping. So let's dive in. So the first thing that the Fair Labor Standards Act kind of breaks down is job classification, exempt versus non-exempt. And this is a great big mystery to a lot of people. We generally call them hourly and salaried, but those are pay types. Those aren't true classifications. So you can, not to confuse you, you can have a non-exempt employee paid on a salaried basis and they're still a non-exempt employee. But in general, exempt and non-exempt. The job classification is the process in which a specific position is either classified as exempt or non-exempt. It should be based on the essential functions actually performed by the employee and detailed in their job description. Exempt and non-exempt are classifications under the FLSA which is that law again that employees receive minimum wage for each hour worked and overtime over 40. Employees who are entitled to those protections, so they're entitled to minimum wage and overtime, are called non-exempt, while those that are covered by those protections are called exempt. While whether an employee is properly classified is determined on a case-by-case basis, a best practice when creating job descriptions is to determine employment classification, and the top 5 essential duties should be listed at the top of the job description. These should be the main duties this employee does daily. A human resource manager would not automatically qualify for a management exemption simply because the position's title includes manager. The individual in the position must meet those other things that the IRS says. So they must, or in the Department of Labor says, they must meet the salary level, the salary basis test, and the job duty requirements of those exemptions in order to qualify as an exempt employee. So when a business classifies all their salaried employees as exempt or assigns employee classifications based on the job title rather than the job duties and method of payment, you risk violations. The position is classified, not the employee. It is not the employee's decision about their classification and how they get paid. The Department of Labor defines the rules and who is exempt and not exempt. So non-exempt employees, so those hourly employees, right? Payment for hours worked. The Fair Labor Standards Act requires non-exempt employees be paid at least the applicable minimum wage for all hours worked, and time and 1/2 the regular rate of pay for all hours worked over 40 in a work week. In New York, you're working with much higher minimum wages than at the federal level. So that's what you would be doing that overtime calculation off of. The FLSA also requires employers to retain complete and accurate records, including records of hours worked for at least 3 years. It's a big one that's out there. And I was involved years and years and years ago. I was involved in a Department of Labor audit. They specifically were looking at minors and minor working regulations and those violations. And they did go back quite a period. We were lucky we had an automated timekeeping system, but I work with some clients that, they don't really have those time records. They just put somebody's hours in, and that's very, very dangerous. What proof do you have if the employee comes back and says, I worked 48 hours last week, if you don't have a record of them punching in or signing in or doing something? So if you're not currently having the employees track their time, the non-exempt employees, I would put that on a to-do list to get something in place immediately. Doesn't have to be a time clock. It can be a timesheet. It can be an email that they send you. There's so many different things. But think, if you had to prove how many hours that employee worked a year from now, how would you do that without it in writing somewhere? So here's an example for you. An employee was in a managerial role and correctly classified as exempt. When the employee was moved to a trainer role, their classification was not changed, and even though they no longer had any supervisory authority. Following the role change, the employee claimed they were working 17 hours per day and sued the employer for $250,000 for misclassification and back pay. As it turned out, the employee chose to stay in the office. They weren't required to. But in addition to allegedly misclassifying the employer did not have rules to prevent the long hours from happening. It's important to remember that if overtime is worked, it must be paid. An employer can't say they didn't approve it, so they're not paying. An employer must have a policy and a process in place to handle situations where an employee works unauthorized overtime. It is usually best handled through the disciplinary process. But if the employee worked it, you're going to pay them. And how do you calculate that overtime rate? For most hourly employees, they have one rate of pay. And so it would be over 40 hours, it would be 1.5 times that rate of pay. There's a couple of circumstances where it could potentially be more than that. If you have somebody, let's say in a restaurant, they work as a server, part of the time, and then they work as a hostess for part of the time, they may be at two different rates. And so you would have to come up with a blended overtime rate for that overtime pay. So regular rate would include their hourly earnings, any commission, non-discretionary bonuses, and if meals and lodging, if it's somebody that travels, all of those are looked at as part of compensation, and overtime would be calculated off of those. You can exclude if you reimburse them, for expenses or meals, discretionary bonuses, gifts and payment, and holiday vacation or sick pay. This comes up every year after Memorial Day, the 4th of July, Labor Day for me, that employees get paid. And then they say to the employer, well, I worked 44 hours last week, so I should have gotten 4 hours of overtime. And the employer says, well, we were closed on Monday. We paid you 8 hours of holiday pay. So you're not eligible for that. So they are right. The employer is right. Holiday pay can be excluded. If you're closed and you're just paying employees a holiday that day, you can exclude it from that overtime calculation. Usually, the employee isn't aware of the policy, so maybe in a handbook somewhere it should be clearly written out that overtime pay, doesn't include holiday vacation or sick time, or in the holiday day policy saying that that's exempted from overtime calculations as well. So sometimes being a little bit proactive. The one exception to that rule would be that if your holiday pay is worked pay, if you were open on Memorial Day and you paid employees time and a half for Monday and they still worked 44 total hours that week, you would have to come up with that blended overtime rate to figure out how much overtime would be, because you would calculate in 8 hours of time and a half, and then, the other 32 hours of their regular hourly rate, and come up with that blended rate, and then their overtime would be that. So their overtime would actually be more in that example than it would be during a regular week. So be familiar with each type of compensable time worked. I will, when this is sent to you, you'll have the links to the DOL website so you can look at it. Non-exempt employees may not receive comp time instead of overtime. You can't say to an employee, great, you worked 48 hours this week. Next week, you'll only work 32 and it'll cross cancel each other. That's not how it works. If they work 48 hours, they get paid for 48 hours. We talked about this, including all different types of pay when you come up with that overtime rate. Doesn't happen a lot, but you must use a weighted overtime rate for employees that have different pay rates. Be sure to retain complete and accurate records in case of an audit. The type of record determines how long it must be maintained. In general, it's 3 years. It doesn't hurt to have them longer, but think of what you would need to prove your case if somebody comes back with a DOL claim 6 months from now. How could you prove that what you did was correct? When in doubt, I would suggest that you reach out to an attorney that is well versed in the Fair Labor Standards Act, whether it has to do with classifying those employees exempt or non-exempt, coming up with those blended rates. If you can't find it on the DOL website, or you can't figure it out, then that's the time to get an attorney involved to make sure that you are okay. DOL audits can be very, very, very expensive. If anybody's ever experienced one, they can get you for the violation that they came in specifically looking for, plus anything else that they see. Plus, they could then want to do further audits to get more information and potentially more audits. So exempt employees, these salaried employees, they are not subject to the overtime and minimum wage protections of the Fair Labor Standards Act. So to be exempt, the employee must generally be paid on a salaried basis. There's a couple little side ones off of that, but generally they get a salary. They must receive a minimum salary as outlined in the federal regulations or state regulations. In New York, there is much higher salary standards than there are at the federal level. And they must meet the general duties test of one of the white collar exemptions that are out there. And employees paid on a salary basis. Each pay period, the employee receives that weekly amount. You cannot reduce that weekly salary because of variations in the quality or quantity of work performed. They're paid to complete a job on a weekly basis. So if somebody leaves 2 hours early one day, you can't cut them down 2 hours. You can ask them if they're going to make up that time. It's generally not the most employee friendly thing to do. I would kind of trust that the employee is doing it. If the employee isn't doing it, then their quality of work is probably not appropriate or acceptable. And that would be the conversation, not so much that they left 2 hours early. The employer is responsible for supporting the consistent application of that exemption. Employers are encouraged to consult legal counsel, once again, if you're in doubt about the proper classification of employee. When I work through this with my clients, I usually say, when in doubt, they're non-exempt. That's the safest place to be. You can always classify an exempt employee as non-exempt, but you can't go the other direction. You can't take a non-exempt employee and make them exempt. This is a hot topic that's out there. The number one reason why people are classified as exempt and made salary is to avoid paying overtime. And that's not a legitimate reason for making somebody exempt. So here is a listing of the Fair Labor Standards Act exemptions. So these are, we call these the white collar exemptions. So there's the executive exception, administrative, professional, computer, outside sales, and highly compensated employees. So each one of those has, if you go on the DOL website, there's not a lot. I think there's 8 questions that you have to answer, and the person must answer yes to all 8 of those in order for that position to be classified as exempt. Sometimes there's little things that you can add in to make somebody exempt. Manager doesn't automatically make somebody exempt, like I said that before, but maybe people can report to them. Maybe they can have hiring and firing authority. That's generally looked at as an exempt role. So sometimes you can add additional things, responsibilities when you're in doubt or somebody's on the border. So did we have any questions about the FLSA or exempt, non-exempt, or overtime?
No, but I have another question.
Sure.
On the non-exempt side, what about tips?
What about tips?
Is that included in in the total compensation? Yes, okay. There was no
So,
other.
they've got those combined wages where they get paid a lower minimum wage and then they report some tips so that they get to the minimum wage, the tip credit that employers are offered. So let's be real.
But there's tips everywhere now you go. You know
It's-
what I mean? That they're minimum wage employees. I'm sure it's not a lot of money, but I think we've all experienced that it's sort of on everything now. So that would be included as well? Okay.
So depending on, I mean, at Starbucks, going through the drive-through, that tip jar that's right there that people drop their spare change in, that's not showing up on anybody's pay slip or their W-2, right? The employees are not reporting those wages, so you don't care about that piece of it. But with anything that would be reported on a W-2, or on their pay slip as tips, yes, that comes in to that calculation.
Right, because the other way, people don't use cash anymore, right? So it's on display now because of the digital, payment, right? And it's got
I
its own.
don't know, accounting wise, how companies do that. I don't know if they turn it into cash and just hand it out to the employees and don't declare it. I don't know. All tips are supposed to be declared, but I'm a
Okay.
realist and I know that doesn't happen. So I don't know. But yes, if there's tips on their payslip, then that needs to be factored into that overtime rate.
Okay, thanks.
All right. Leave of absences. Like I said at the very beginning, many of you have probably heard about the FMLA. The FMLA is it's a federal law, and it allows employees to receive up to 12 weeks of unpaid job protected leave, but it generally only applies to employers that have 50 or more employees. So a lot of my small businesses, FMLA doesn't apply, but there's other ones that may apply. So there's paid sick leave. In New York and New Jersey, there's paid family leave. And then there's military leaves that come into play as well. We don't deal with the military leaves as often, but there are definitely leaves that apply to all employers as well. So employers should develop or update their employee handbook to help ensure compliance with applicable leave laws and any other relevant policies or procedures. I always say it's better to have it written out. So if somebody comes to you, you can just refer to that with exactly what your requirements are. Employees, it could be self-service for them, right? They could read it and know what they get to start with. And that way you're kind of going to be consistent as you apply those rules to everybody. If an employee requests any type of accommodation or leave of absence, it's important to discuss it with the employee to determine what the request is for, how long it's for, and if there's any other options. Employers should document these types of accommodations, requests, and conversations. So where this comes up, and this would be its whole nother seminar if we talked about it, is the Americans with Disabilities Act, ADA. You could have an employee requesting a leave of absence, and you don't have to do FMLA. Maybe they've exhausted their sick time, but it may be eligible for a leave of absence under the ADA. So kind of just keep that in the back of your mind as well. That's why having somebody put it in writing is always the best route. And then honestly, I encourage all of my clients outside of their legal obligations, I encourage them to have some sort of personal leave policy that's in place. Life happens, right? And it's better to have a policy with guidelines for when those situations happen. So you have an employee that, they've been with you for 15 years and they break their leg and they're unable to come to work for 6 weeks. You could say to me, well, yeah, I'll just, they'll be back. I'll just take them back. But when somebody else down the road requests time off for a medical reason and you don't have the same process, I'll take them back, attitude, that's where you run into problems. So having just a basic personal leave of absence policy, you can set the rules. You have to be with us for a year. It's unpaid. We may not put you back in the same position when you come back. We're not going to maintain your health benefits while you're gone. Like, you get to set the rules and then put people into it. Just kind of, I think it's a good practice. And I think it's good for employees too, to have some options. Talking to the employees, figuring out what it's for. I have some clients that take a really hard line, right? That they have employees that need 3 weeks off because they're going back to their home country and they're not allowed to take that time off. Well, let's just be realistic, right? If this employee's been with you for a while and they're a good employee, they already know the job, are you really going to hire somebody and have them up and trained and ready with the same knowledge and information that this other person had by 3 weeks? Probably not. So yes, it's a inconvenience to have that employee gone, but it's probably the best decision for the employee and for the business to offer some sort of leave. So start with asking them to put it in writing, how much it is, and then talk to the employee about what you can do and what you can't do. So that was a quick little one. So just so you know, in New York, unless you're super itty bitty tiny, everybody should be earning 1 hour of sick leave for every 30 hours they work. Part-time full-time, seasonal, you're required to show all of those accruals. So we talked about record keeping under the FLSA. That would be something that you have to maintain those records if they asked for them. So if you don't have that currently in place, get it in place. Were there any questions that came up on leave of absences?
No.
All right, workplace investigations. There are many reasons that an employer may need to conduct a workplace investigation. So let's discuss some types of things that may warrant an investigation if they occur. So harassment. The U.S. Equal Employment Opportunity Commission, the EEOC, defines harassment as unwelcome conduct that is based upon race, color, religion, sex, and under sex, that includes sexual orientation, gender identity, and pregnancy, national origin, age, disability, and genetic information. Harassment becomes unlawful when enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Now, I get a lot of people over all my years in HR that have knocked on my door and said, I'm being harassed. Doesn't mean that they're being harassed, but it means that I'm gonna listen to them, right? It might not rise to the legal definition of harassment, but I want to make sure. I want to make sure that I'm going to get all of those answers so that I feel comfortable about the condition and the direction that my business is going to take. But people like to throw harassment out there without it being the legal definition. Violence. OSHA defines workplace violence as any act or threat of physical violence, harassment, intimidation, or other threatening, disruptive behavior that occurs at the work site. It ranges from threats and verbal abuse to physical assaults and even homicide. Bullying. Workplace bullying is generally described as persistent, unwanted, offensive behaviors that are intended to humiliate, threaten, or intimidate somebody. These behaviors can either be direct or indirect, led by one or more persons against another or a group of people. Discrimination. There's various types of discrimination that are prohibited by the laws enforced by the EEOC. I mentioned them before: age, disability, equal pay, compensation, genetic information, harassment, national origin, pregnancy, race, color, as well as others. There's a bunch of different ones that come in different localities. There's a fine line between some of these incidents, but that's where the investigation process comes in to help you clarify if you need to take any action. When an employee informs you of a workplace situation, you must determine if an investigation is warranted and how you'll respond. Consider the following. What is the nature of the incident? Ask the complainant to document the issue in writing. And if they don't want to do so, or they're not comfortable doing so, you can take notes and then ask them to verify the information or sign it, or ask them if there's anything else they need to add to it. But keep in mind, just because they refuse to put it in writing doesn't mean that it didn't happen, doesn't mean that it's not something that you don't have to investigate. So things to think about. Is the complaint about something significant, such as a violation of law? For example, harassment or discrimination. Is this a significant violation of workplace conduct or a policy? So, for example, was it a safety violation, theft, or violence? Is there more than one individual involved in this incident? Is the complaint based upon a pattern of misconduct, or is this a single incident situation? You're going to ask yourself, are there more facts that are needed? What's the source of the complaint? Is the employee reporting the complaint for themselves or on the behalf of somebody else? Did the employee mention other individuals that may have been involved or have information about the incident? Can you verify their complaint with anybody else? Is special expertise needed? Depending on the nature of the situation, you may need additional expertise to resolve the matter. If there's a potential violation of the law, consider involving legal counsel. Generally, when the employee making the complaint says that they have talked to legal counsel already, you need to be talking to your legal counsel as well. If theft has occurred, or if there's a workplace violent threat, if you have security, you're going to get them involved, or law enforcement. I had a situation not too long ago where there was an employee who had been terminated. He returned back to the work site, didn't get into the building, but was outside. And when they called me, I said, but that's a police matter. You really have to call the police at this point in time to get him removed. That's not anything internal that you're going to handle. You're going to get law enforcement handled. The same thing if anybody threatens any of your employees. You can call on their behalf, but generally, I would recommend that the employee call the police and make the complaint. Here's just a general overview of the process. So first, you need to identify who is going to be doing this investigation and the parties involved. So the investigator can never be anybody that's part of the complaint. Just if you weren't aware of that, they can't be part of the complaint. Plan for the interviews. Who is going to be spoken to? That person must remain neutral. They must help employees feel as comfortable as possible. They must ask the right questions, and they must be able to let somebody else speak. So remaining neutral is probably the biggest one that I see come up. We are very judgmental as a species, right? We instantly form our own opinions, and it's hard to overcome those. I've been in investigations where, I have to tell my internal monologue little voice there to shut up. So that it doesn't prejudice what I'm hearing from somebody. You'll also want to ensure that there'll be no retaliation for having brought the complaint or participating in the investigation, making sure that people know that. Thank them for bringing it forward. You can't correct it if you're not aware of it. Interviewing. Interview the complainant, the accused, and any identified witnesses and document each interview. Some basic questions. What happened? Who said what? Where did this take place? When did it happen? What was your response? Who else was present? Is there anything else you'd like to tell me? I generally ask too, has this been happening? How long has this been going on? Was this the first time? All of those good questions. After interviewing, review the facts gathered and make a determination as to what you believe happened. Considerations when looking at all that information. Is there a history of allegations? Are there testimonies from some of these witnesses? Were there indirect admissions? Were there motives to lie? You kind of have to do your best guess, or your best gut instinct at that point in time with, what you feel. A lot of times when it's a he said, she said, and there's no witnesses, there's no camera, there's not too much you can do, right? You can't really take sides unless this is the 10th time somebody has come forward and said the same thing about this other individual, right? That's where you would take into account the history of allegations, right? I've sat there across from somebody and said, look, I understand that there are no witnesses. I understand that you're saying this didn't happen, but this is the 10th person in the last 3 years that has come to me and said the same thing. So that kind of leads me to believe that there's some inappropriate behavior happening here. Let's talk about this further. So I'm not accusing, so to speak, but I'm trying to fix the problem. I'm trying to get to the bottom of it. So taking action. After analyzing and determining if misconduct has occurred, appropriate action and notify the appropriate parties that the action has been taken. If no tangible action has been taken, it's important to follow up with the complainant to let them know that the investigation has been completed. This is where a lot of people go wrong. Sometimes an investigation takes too long, or they think they resolved it and they never went back to the original person and said, hey, want to let you know, we did investigate this and we took the appropriate action, or the action that we feel is appropriate. If anything further happens, you have any further issues, please come to us, right? You're under no obligation to tell them exactly what actions you took, but you're closing that loop for them. So they know that it was looked into and they know that there was a resolution that's there. So make sure you don't forget that piece of it. Finally gather all the documentation created and create a final report that summarizes it. I generally just tell my clients, keep it all in a folder, but put like a timeline. When the person came to you, when you spoke to everybody, just so you can follow through. These things don't generally show up like 2 weeks after you do an investigation. These generally show up like 6 months down the road. And so our memory gets a little bit fuzzy and we forget some details. So if you take notes as you go along and you keep that timeline, it'll be your best friend if it ever comes back up again. So some best practices to remember. Ensure there's no retaliation against employees who file the complaint or participate in an investigation. Ensure all employees, including supervisors and managers, know and adhere to policies against harassment, discrimination, and retaliation. In New York, it's required that you provide sexual harassment training annually to all of your employees. So that's a good way to educate them about sexual harassment, but also other forms of harassment and discrimination. Have an open door policies where employees may bring complaints to any member of management to which they feel comfortable. Conduct a prompt, thorough, and impartial investigation of all harassment and discrimination complaints. And if you're responsible for conducting those investigations, document each one of the steps. Like I said, it'll help you down the road if it ever comes back. All right, were there any questions on investigations?
There was one, and you answered it actually as you progressed with your presentation, but I think Bart has a question. When you are interviewing people, must you interview all employees who were involved, or can you cut the interviewing short if you have made up your mind before talking to a few employees?
I think it matters how many people we're talking about. So if I have a harassment claim and the person gave me 20 witnesses, and after 5, they've all said the exact same thing, I'm probably comfortable at that point in time, right? That I have 5 people that are all on the same page about exactly what happened. But if it's, maybe only 5 people total involved, and those 2 first people I interviewed, their stories don't quite match up, then yes, I would keep interviewing everybody. I'm always reminding myself to be kind of the devil's advocate, right? Trying to always put the shoe on the other foot, trying always to look at it from a different angle. And I want to make sure that I am fair. I don't ever want to be blindsided by something that I could have found out if I had talked to one more person. So it really is going to be case dependent and situation dependent. All right, our last little topic, effective employee discipline and termination. To continue to let a problem go unaddressed is sending a message that a performance or behavior is acceptable. So let's review some effective ways to address employee performance and behavior issues. When employees have issues in the workplace, generally it's either a performance or behavior issue, and it's important to understand which type the issue employee is having so that you can help rectify the situation. If an employee is having a performance issue, they're failing to meet the requirements of the job. Generally, job requirements are defined by a job description, performance objectives, policies, and the organization's culture. So an example of a performance issue would be an employee who's not meeting their monthly sales quota. So how could you address that issue? The employer could place the employee on a performance improvement plan and work with the employee to determine how they could meet that monthly quota, or if there's additional training, partnering, something else that they need to do to help get that employee to meet that sales quota. The employer should have frequent follow-up meetings with the employee to ensure that those expectations are being met. If the employee continues to not meet their sales quota after the employer has done these other things, then the employer can start the progressive discipline process at that point in time. Or they could decide that there's been some improvement, and so they're going to provide additional coaching or mentoring to get that person all the way where they are. Behavioral issues are when an employee who is intentionally doing something. So they're disruptive during a team meeting by shouting or speaking over others. They know what it is. So attendance, right? Somebody who's late every single day, that is a behavior. It's within the employee's control. If you have a policy in place and they violate that policy, that's a behavioral situation. And we generally jump right to progressive discipline when it's behavioral, as opposed to a performance issue. Documentation is important, and employers should have thorough and accurate documentation of any disciplinary steps taken. The documentation should clearly state the problem. They should ensure that the problem is described objectively and cite specific examples. I generally tell my clients when they're writing out, exactly what happened, they write out exactly what happened. They don't need to editorialize. Generally, they should leave adjectives out of it. Adjectives tend to cloud our take on something. And they should put exactly what happened. Years ago, I was working in stores. There was an employee that used profanity in dealing with a customer. The customer called the 1-800 number and complained. And when the manager went to write him up, that's what they put in there. They put that the employee used profanity. Well, that's kind of subjective, right? Different people are offended by different things. I'm not going to use the bad words right now, but it was quite explicit what the employee had said. And so I told the manager to make sure that they put exactly what the employee had said in that write-up, exact facts. So it couldn't be, the difference between what's okay and what's not okay. It was quite explicit. So put the specifics in there. Include the employee's name and the date of that warning, and then reference any previous conversations about the problem. Is this the first time you've talked to them, the second time, the third time, the final time you're talking to them? I would say previously warned for foul language on, June 5th, 2024. So you would show that this is a pattern with that employee. While several issues can be grouped within a warning, be careful of the timing. Mentioning prior issues should be restricted to an appropriate time frame depending on the infraction. For an example, if an employee was late for work 2 years ago, you're not going to bring that up now on a new warning because that was 2 years ago. If they were late 2 years ago, they were warned, and then for 2 years came to work on time, you're starting over fresh with that one. To take disciplinary action against an employee for a behavior that's been going on for a long time can also be unfair, and also can be suspicious if it could look like you're targeting that employee. So to stay with the time and attendance warning, generally use a time frame, right? If you've been allowing somebody to be late for 2 years, that's on you. When you write them up, you're just going to look at the last 6 or 8 weeks to give the picture of their attendance. You're not going to say, since we hired you, you've been late every single day, because you let it happen. So just use a very specific time frame. Discipline must be timely to be effective. I have clients that call me and they want to fire somebody. And when I ask what happened, I always ask when it happened. And if it happened 3 weeks ago and the employee's been working for 3 weeks and nothing has been said to the employee, there's no investigation happening, but now you want to fire them, that's a hard no. It needs to happen timely. If whatever they did was severe enough to warrant them being terminated, then you need to make it happen the next time they come to work. Make sure when you are giving disciplinary conversations that you're communicating the next step to employees. I'm quite confident you're going to be able to fix this, but if you don't, there's going to be further disciplinary actions and it could lead to your termination. One of my famous quotes that I always used is I would tell people they're putting their job in jeopardy with that behavior. Indicate that there must be immediate and sustained improvement. It says to stay away from specific timeframes because then the person might think when they're on the other side of that time frame, they don't have to do that. But I'm going to disagree that when you're talking about performance issues, that's when you do want to set specific timeframes. Behavioral issues should just be open, right? Once you bring it to their attention, it should never happen again. And written and final warnings should be signed by the employee. But if they refuse to sign it, that's fine. They're just signing that the conversation happened. By not signing it, it doesn't mean that the conversation didn't happen. I would just write refuse to sign and be done with it. So, best practices. Apply a fair and consistent process and follow through with regularly scheduled meetings with employees. Train all supervisors and managers on how to properly document progressive discipline and set clear expectations to ensure an opinion should be removed. Employers should create and implement a robust standards of conduct policy that addresses employees' performance and behavior in the workplace. So even if you don't have a handbook, this would be the one policy that you should have and share with all employees. And never assume that an employee knows their behavior is an issue. Um, Attendance is one of my greatest ones, but I have found myself on the other side of a desk having a performance conversation with an employee that we were, I want to say it was like May. I don't even think we were halfway through the year, and they had already missed 19 days of work for various reasons. And they didn't see how that was a concern, that they had missed 19 days of work. So don't assume that everybody has the same standards that you do. Documenting disciplinary actions can provide evidence that the company took lawful actions and may help the company respond to allegations of discrimination by showing that the employee was treated as other employees were treated in the past. So some steps you can take to take action today. Make sure you have job descriptions. We hit on those in a couple of these different topics, right? Provide employees with an employee handbook, company policies. If you don't have a handbook, then just maybe some of these specific policies you would have. Employees should sign off that they have received those documents. Managers must take action if they have observed or learned of a behavior that doesn't meet those company standards. They are the ones that are responsible for holding the employees against any of these violations of company policies. They must play an active role in that. They're your eyes and ears. Be sure to provide consistent management training to them so that they are comfortable with the process and they don't cause additional issues for you down the road. So we went through and we talked about I-9s, wage and hour, leave of absence, workplace investigations, and employee discipline and termination. Like I said at the beginning, these are the top things that I spend the majority of my time dealing with my clients. So I'm hoping that you were able to pull something away from it. As I said in the beginning, you're going to get a copy of the deck and you're going to see some of the resources, the links that are there that you can go and kind of read up on some of these topics yourself. Were there any final questions that were out there?
No, I think you covered it well. I know it was very educational for me as well. So thank you for that. Thank you for those that attended. As Karen said, you will get a copy of this presentation as well as the recording. SCORE's caring volunteers like myself and Bart are available for mentoring to assist as always by email, phone, and video. We do in person as well if needed. So thank you for attending. And again, thank you, Karen Hall from Paychecks. This was very informative. Thank you.